So the first case that we cover in this section is Schenk v. United States. The case occurs very early on, 1919. The opinion is written by Justice Holmes, and it is a unanimous 9-0 decision. So what are the background facts of this case? Well, Schenk is the head of the Socialist Party in the United States, and he's convicted of violating that Espionage Act that I talked about earlier. So what did he do? He published a circular, so think of it as leaflet, basically, that argued that conscription in the draft violated the 13th Amendment's prohibition against slavery. The circlet that was also provided that each draftee, each individual that was drafted, had a right to assert his opposition to the draft. And for this, Schenk was prosecuted under the Espionage Act. Schenk's argument was that the First Amendment protected his right to oppose the U.S.'s war effort. The Supreme Court unanimously disagrees with that. So what is the issue in this case? And the issue is, does Schenk's circulation of that leaflet, or does Schenk's prosecution for the circulation of a leaflet violate the First Amendment? And the court here unanimously says no, it doesn't. This is the case, as I mentioned in the last slide, where the court articulates its clear and present danger doctrine, which simply states in very basic terms that the government may suppress speech only when it represents a clear and present danger to society. So under this test, if the words that are used in such a way and under such circumstances represent a clear and present danger that will bring about substantive evil, then Congress has a right to suppress that speech. The question that one has to deal with this law is proximity and degree. And historical context sort of gives a background to this. Since the United States was in World War I, was currently at war, the circulation of the leaflet presented a clear and present danger to the United States war effort. Therefore, the court affirms that conviction. But let's say, for example, that the same leaflet was distributed, but the United States was not at war. The court seems to hint here that that would be a substantially different effect, and since there would be no ongoing draft, then it would not hinder the war effort. But in this circumstance, at the very time it's taking place, this leaflet was directed to individuals who were being drafted and attempting to have them oppose the draft and actively oppose the war effort. That could have, at least the court argues, some significant effect on the U.S. war effort, and therefore is a violation of the Espionage Act, and that the enforcement in this case is not a violation of the First Amendment. So the contextualization of this case is important. When it takes place is important. And the court understands what it's doing here because it hasn't really ruled in many First Amendment cases up to this point, despite at this point a long history. It really hasn't weighed in on many of these cases. So a line that you're very familiar with, Holmes drafts in his opinion that the most stringent protection of free speech would not protect a man from falsely shouting fire in a theater and causing panic. So giving the example that, yes, the government absolutely has the authority to respect speech. Speech is not an untouchable right. And in this case, Congress can prevent certain sorts of actions and the speech associated with those actions from taking place. Nowhere within this opinion, however, do we see what we would call the absolutist viewpoint. Because the First Amendment is pretty clear. It says, Congress shall make no law abridging the freedom of speech. there's no wiggle words in that First Amendment. The First Amendment is sort of notorious for being straightforward and also pretty clear. And so Congress shall make no law abridging the freedom of speech is absolutely nowhere espoused within this case. So the court ultimately rules that the government has a right in this case to defend themselves. But the question thus becomes very quickly after this, how far does this right go? And how far can the government go in terms of suppressing speech? This is what the court sort of struggles with in this area. And we'll see the court struggle with it in subsequent cases. This appears to be, because of the nature of the leaflet and who was circulating it, the head of the Socialist Party, actively arguing against the draft during a time of war, that seems to be a circumstance by which the court was much more willing to sort of put their foot down and say, yes, the federal government can absolutely enforce these laws at this time under this nature, in this case. But what happens if what is being advocated for and where it's being advocated and how it's being advocated and who it's being advocated to doesn't nearly reach the standard that exists within Schenk? And that's what the court addresses in the next case. Questions? No questions about Schenk v. US? Oh, maybe there is. Would that be affected by time period too? Yeah, absolutely. And that's kind of what I meant by talking about that we're at war, and that actively being at war was really the catalyst here. The court seems to be very clear that if the United States was not at war, then arguments against the draft are not as problematic. If the draft isn't actually going on, then who cares? They're advocating against the draft. They're arguing that drafting is slavery, but there's no draft underway, so they're not actually hurting anything tangible. So there's nothing, when you're not at war, that would be harmed national security-wise by making that argument. But that they're at a time of war, and that the outcome of the war, at least at this point in 1919, was not a foregone conclusion. Yeah, absolutely. The court says that falls under a clear and present danger to the national security of the United States.